Welcome to the lecture for crisis intervention. We're talking about Chapter 4 of Aguilera, legal and ethical issues. And actually, a lot of the stuff we talk about will be things that are even outside of Aguilera from other sources, because I think Aguilera doesn't quite do justice covering all the issues you need to be aware of in terms of ethical and legal concerns when doing crisis intervention work. So the first thing we need to do is talk about ethics and the law. Are these things the same or are they different? Well, obviously they're different. But how are they different? One way they're different is in terms of the consequences that you may be subject to if you violate them. If you violate the law, you break the law, you're subject to penalty by some civic, state, or federal authority. If you violate ethical principles or codes, you may be subject to a penalty by an organization who's adopted some ethical code if you belong to that organization. If you don't belong to that organization, there's really nothing that they're going to do with you. But if you're practicing mental health, that means you're going to be licensed. And so if you violate ethical codes, even if you don't break the law, you may be subject to penalty by the body that licenses you to practice in our profession. And in Texas, that'll be the Texas State Board of Examiners, and it's the examiners of psychologists or examiners of marriage and family therapists or examiners of professional counselors, depending on what license you have. But essentially, it's some state body that sets the minimum requirements to be licensed, and then if a client or colleague wants to file a complaint against you for ethical violations and malpractice, they could file it with that board, and they could sanction you, take your license away, fine you, require you to do education, a couple different things they could do. Ethics and law also differ in their purpose. The law is there in general to protect the citizens, right? The citizens of the city, the state, the country, depending on what kind of level of law you're talking about. In ethics, there's some overlap here because one of the purposes is to protect, but it's to protect clients in particular. We're talking about ethics for the practice of mental health. They're not there. The ethics codes aren't there to protect practitioners. They really are there to protect clients. But in addition to protecting clients, the ethics codes, the principles are there to kind of encourage quality care. So it's not just about keeping bad things from happening to them, but if you practice ethically, the idea is that you're going to maximize the quality of care that clients receive, and if you practice unethically, you'll be getting in the way of quality care. So where can you find what the law says or what the ethics codes are? I've put some links up on our Blackboard page that will take you to a couple of places where you can look at legal statutes and ethical codes. And most of the laws you'll need to know about are state laws. So if you're going to stay in Texas, I put that link up obviously. If you're in a different state, it'll be a different set of laws. And which ethics code you should probably pay the most attention to will depend on your type of license and what organizations you belong to. For me, I'm under APA's code. I'm a member of the American Psychological Association. I think it's also probably one of the most comprehensive codes. It was one of the early ones. So if you're not sure, I'd say look at that one. It's a pretty good one to go by. You shouldn't get in trouble if you follow those dictates. Okay. So what happens if there's a conflict between the ethical code or principle and what the law says should happen? Well, one thing that I want you to try to think about are when might this happen? And this is one of the things we discuss in class. We kind of make a mental note or jot it down that one thing we're going to talk about is, I want you to be thinking about when might ethics and ethical obligations and legal requirements come into conflict. Okay. So when those things do happen, and you'll come up with examples, you are allowed to violate the ethics code if you're mandated by law to do something. But you don't have to. You can break the law and be ethical. If you do that, though, you have to be willing to accept the punishment of the law. So you can go to jail. If a judge orders you to divulge something about a client and you don't think it's the right thing to do, you could stick to your kind of ethical guns, but you're going to go to jail for contempt. And that's a choice you can make. But in most ethics codes, they allow you to violate the code if the law says you should. So the law kind of trumps, or is allowed to trump ethics. from the standpoint of most of the codes in our profession. So, like I said, I want you to think about when this would happen in terms of does one trump the other? Yeah, law trumps ethics. At least it can, but again, you don't have to let it trump. If you want to suffer the consequences of the law, that would be your choice. Okay. Another idea that Aguilera does cover is this idea of therapeutic jurisprudence. And traditionally, one of the relation between ethics and the law is most of our laws are drafted, they're composed based on some sort of agreed morality or agreed upon ethics. In therapeutic jurisprudence says, okay, well, instead of just kind of translating ethics into law, when we're looking at law that affects mental health and mental health care delivery, what we should be looking at, in addition to kind of what's the right thing to do, what's moral or ethical, is look at empirical evidence about the effects of laws and policies, and in particular the therapeutic effects. So having a certain law or policy in place, does that help people get better, or does it keep people from getting better? An example that comes to mind is, if empirical evidence suggests that incarcerating someone for a drug offense doesn't lead to a change in drug-related behavior, so you imprison them, they get out, and they go back to using drugs, and they go back to prison, and you kind of keep doing that, well then clearly the response of the law isn't changing the behavior in terms of therapeutic outcome. And if the evidence says, well, treatment does change the behavior, at least at a higher rate than incarceration, then you would hope that the sentence for drug offenses would be mandatory treatment rather than mandatory incarceration. So it's just kind of one example. So it's about therapeutic jurisprudence is about looking at the therapeutic outcomes of law or policy. So, what does it mean to be an ethical professional? Well, to some people it means stay out of trouble. Right? Read the rules carefully and make sure you don't break them because you don't want to get sued or go to jail. And that is one way to conceptualize being an ethical professional. But I don't think it's a very helpful view. A view that I like better, makes more sense to me, and I think is ultimately more helpful to professionals in training, is thinking of it from the point of view of vigilant ethics, which is a term that Kuchar and Keith Spiegel introduced in their work. And what vigilant ethics means is you monitor yourself, you're vigilant, you monitor yourself and others to make sure you do the right thing and not to avoid doing the wrong thing. And I know at first this may sound just like semantics, and oh, you're really saying the same thing, but there really is an important attitudinal difference that will affect the way you behave as a professional. When you're working to be ethical because you believe it is right, and more importantly because you understand that ethical conduct is in the best interest of your clients, when you're kind of working from that point of view, you're more likely to provide quality care because you don't have this kind of cloud of paranoia hanging over your head when you're trying to be fully present with your clients, worrying about, okay, are they going to sue me? Am I saying the right thing? You're worrying, okay, what's the best thing to do for this client, with the background knowledge of some guidelines for what as we as professionals in general agree upon our best practices. So in terms of what should you be vigilant to do, what should you strive for, well, there are a couple of key values that are represented in most of the major ethical codes, APA, ACA, LMFTs, or LMFTA, their code. And they use different terms for it sometimes, but that basically are beneficence and non-maleficence, right? So do good and don't do harm. Respect for autonomy, the recognition that clients have a right to self-determination. Justice, be fair and equitable. And fidelity, tell the truth and keep your promises. So these are the basic values. Let's take a closer look at these now and see how they really translate into actions, especially in the context of crisis intervention. Okay, for beneficence and non-maleficence. So do good, don't do harm. One thing that you might think of, okay, well, if I'm supposed to do good, then if something happens, there's some crisis, do I have to help? Is there an obligation to render aid? You're driving down the road and there's this 20 car pileup or a bus turns over. Clearly a crisis. People are screaming and crying, maybe being traumatized by what's happening, and you have some training that suggests that some intervention right now might prevent later psychological damage. Do you have an obligation to stop and use your training? Because again, one of the key values is do good. Well, no, there's not an obligation, because these kind of values aren't written into the code in terms of what you must do and what you must avoid doing. That's when it gets kind of the specifics of the ethics code, and each code differs depending on which one you're looking at. But if you did stop and render aid, it would be in the spirit of the values. So these values really are aspirational. You're not bound to do good, but we aspire to do good and not to hurt people. Similarly, you might think, okay, well, what if I'm working with somebody in a crisis situation and my intervention doesn't work, or I screw it up, or my office gets broken into and some confidential client information is taken. Am I going to get in trouble for that? Have I been unethical? Well, whether or not you've been unethical depends. And it doesn't depend on does harm happen, because sometimes things are beyond your control. When it's beyond your control, you didn't commit an ethical violation. It's unfortunate, and we wish it didn't happen, but it was beyond your control. So the key here is the harm foreseeable? So could you, based on the actions you took, could you foresee that this bad thing was going to happen? Or knowing how the world is, for your office, do you have locks in your doors or not? If you don't have locks in your doors, then that's, that may be an ethical violation in terms of negligence in protecting your client's information. So you're not expected to be godlike in preventing any bad from happening, but you are expected to take reasonable steps to prevent harm. And it's all about taking into consideration the likelihood of harm for some course of action, some decision, and then the likelihood of benefit for that course of action decision, and then making some judgment about what to do. And as long as you kind of consider everything and aren't purposely trying to hurt somebody, you're acting in good faith. You're acting as an ethical professional. In terms of respect, autonomy, for crisis intervention, one thing this is about is you can't force or coerce people into intervention. Just because you kind of know that they need it. So if maybe you have an ongoing client that while they're seeing you to work on something, they experience a traumatic event, right? And the client deals with this by drinking heavily, and the client says, no, I don't want to talk about the event in therapy. I came here to talk about some conflict with my boss at work. I want to stay focused on that. That's what we agreed to talk about at the beginning. That's what we're going to talk about. So if you as a professional believe that the client's going to suffer harm if you don't address the event, but the client says, no, I don't want to talk about it, now you're kind of caught between that obligation for beneficence, right? So and I'm supposed to do good, and I think doing good means talking about the event, but they don't want to talk about it and have to respect their autonomy. So what do you do? And again, this is another thing that I want to talk about in class, so kind of make a note. What would you do in this situation where there's something, an issue they don't want to talk about, but based on your experience, based on theory, based on empirical evidence, that they need to talk about it? What do you do? Now, slightly modified situations, I imagine most of you are imagining an adult client. Now imagine that client is 16 years old. Does that change what you would do at all? And think about maybe why it wouldn't. Okay. So this is in respect for autonomy. We just come with an example there where it kind of conflicts with the obligation for or the principle of beneficence, and this is one that really comes in conflict with the other values frequently, because most of the values are about protecting and being good to clients, and sometimes clients make poor choices. So there's this inherent struggle between trying to keep them safe and do good for them, but allowing them to continue to make poor choices. And it's not always easy to say, okay, well, this value wins over that value. And that's when an ethical decision-making process needs to be pursued. Okay. Justice is another one of the values we talked about. So for crisis intervention, imagine you decided to offer some intervention services pro bono following some events. Maybe there's a school shooting, uh, and you say, okay, I'm going to go offer some counseling, brief counseling to the kids. It would be unjust to only offer your services to kids whose parents you know. It's kind of easy one. And that's probably also ethically problematic for some other reasons as well, which we won't get into. Another example, imagine you maybe want to do some research on crisis intervention. You want to test some intervention, and you test some new therapy, some new method on some vulnerable population. Maybe some low-income population, which that maybe they're easy to recruit because you have financial incentives, and so you can get them into the study, doing this kind of maybe risky intervention. And then after doing the study, you realize that the intervention would work. You can just change one aspect of it. So then if you go off and offer the intervention to some other community, probably for profit, without giving anything back to the original community that was kind of sacrificed in gathering information, that would be unjust. And again, that's not a violation of any particular piece of the code in any ethics code, but it would be contrary to kind of this key principle of being just and fair. The last one is fidelity. One really key thing here is, in terms of telling the truth and being honest, keeping your promises, is not misrepresenting your credentials or experiences. So after you've completed this course, you cannot ethically call yourself a crisis intervention expert. I'd love to think that this course will be able to do that for you, but it can't. One course can't make you an expert on a topic. It takes coursework, practical experience, supervision, and frequently some certification or licensure in an area to really call yourself an expert in that area. So you don't overstate what you know or what you have done, and you don't practice outside of your area of expertise. But, and this is a big but, especially for this class, there's a general exception made in crisis situations. So if you don't have training working with kids, but again there's some tragedy of school shooting, and they put out a call for all therapists in the area come down and be able to be ready to listen. These kids need to talk. Even if you have no training working with kids, in that situation, if you're the only therapist there, you're in maybe a rural community, isolated, and there's all these reasons why nobody else can help and they need something now, you're permitted by the ethical codes to go and do your best. But you do your best while being very careful not to inflict harm. So you don't go and say, okay, well, I'm going to go in and use what I know with adults, and I'm going to do some intense psychoanalysis, and I'm going to schedule to see this whatever kids I get for the next couple of years. That would be unethical. You do the best you can, but you can take reasonable steps to minimize any damage you might do. But again, in emergency crisis situations, you are allowed to practice outside of your area. You're given some leeway there. Okay, so we've talked about the general principles now, and I won't go into the details of all the various codes because that would be a whole other class on ethics. Well, let's look at some of the ethical and legal issues and situations that may come up, maybe more relevant when doing crisis intervention work. One thing which overlaps with just therapy in general is the importance of confidentiality. So one thing that when thinking about our ethical obligation for confidentiality that I want you to think about, again we'll discuss in class, is what are the key values that we're adhering to when we work to maintain confidentiality. So why is confidentiality so important in terms of those values we talked about earlier. Okay, so related to the values, but also know that it is important. It's really a cornerstone of our profession. It's a big deal, not just because we don't want to embarrass people by letting their secrets out in the world, but it's because the work of therapy hinges to a great deal on the establishment of a trusting relationship. If we didn't take confidentiality seriously, it would be really difficult for clients to trust us, as professionals, and therefore harder for therapy to work. So the idea is that therapy can't work if we can't guarantee people a pretty significant degree of confidentiality. Okay. So, kind of what is confidentiality, and how is that different from this idea of privilege which you may have heard. So confidentiality is an ethical obligation, and it's an obligation of the therapist to protect information we have about our clients. Right? The client doesn't have an ethical obligation not to talk about something we say in therapy or their own stuff. We have that obligation because we have kind of a professional code of ethics. Privilege is different than confidentiality, and they overlap, but privilege, so confidentiality is an ethical obligation. Privilege is a legal term. So privilege is legal, confidentiality is ethical. Privilege is a legal term that refers to a client's right. So the client's right now, the other one was our obligation. Now it's privilege is the client's legal right to not have their information shared with others. So you may hear the phrase, the client is the holder of privilege. So this means that the client can determine if they want to give up that privilege or not. So if they want you to share information about them with someone else, with their partner, with their parents, with their lawyer, then you do so. Although you think about it, and if you think it will cause harm to do that, you let the client know that you think it will cause harm, and then if they still say you must do so, then you've got to do so. But you don't have to just do it automatically. You can you have some room there to use your professional judgment about whether or not it's in their best interest for them to revoke their privilege. So ultimately it is their right and their decision. Another difference kind of between privilege and confidentiality, privilege only exists in the context of a professional relationship. So if one of your friends tells you something and they think that well, you can't tell anybody because you're a therapist, no, that's not true. Unless they're paying you and seeing you as a client, which is bad. Don't do that. But just because you're a therapist, you don't have to. Anything people tell you isn't privileged information. It's only when there's an existing professional relationship. Now, the threshold for establishing the obligation of confidentiality is a bit lower. So if you kind of assure a friend, oh, I'll keep your information confidential, and they believe you because of your status as a therapist, well, now the ethical obligation for confidentiality probably kicks in. So be careful about putting yourself in a situation. And for other ethical reasons, it's really best not to get into a therapist role with your friends or family. It's okay to be therapeutic, but you don't want to be their therapist. And it's an important distinction to make. In terms of confidentiality, specifically in crisis situations, so if someone is brought into your office after experiencing some traumatic event, so they're in crisis, they may not have the time or the ability to fill out all the paperwork that you would normally have to do, maybe even the informed consent, and they just need to know, what do I do now? What do I do? So a question that might occur is, well, if I talk to them, if I kind of give them some basic advice, have I established a professional relationship and kind of locked in that obligation of confidentiality, and they now have this right of privilege? Yeah, I would say they do, especially if it's kind of clearly in your office. And even if you're out in the field doing work, again, you come across the bus, there's still the obligation of confidentiality and the right to privilege. But it may not be kind of reasonable, possible to keep or maintain the typical level of confidentiality if you're out in the field. You're riding in the ambulance to somebody to the hospital, kind of helping them calm down. You can't tell the paramedics to step outside, right? So you take reasonable steps to protect their confidentiality. You don't you don't talk loudly about what they're telling you. You may try to get them to a quiet place. In terms of the informed consent problem, kind of in crisis situations where they need to talk to you now, even if you don't have time, I'm going to go through my 5-page form about informed consent. You can give them a real quick spiel to kind of just let them know the basics of what's involved in informed consent. So something like, I'm here to help and to listen. I just want to let you know I'm legally and ethically forbidden from going around just telling anybody about what you talk with me about. Okay, but there's a lot going on right now, and I may need to share some of what you tell me with others in order to make sure you stay safe. Do you understand? And at bare minimum, try to do something like that. A couple of sentences to kind of let them know that I'm not going to go tell everybody about this, but you're in crisis, and I may need to, tell this doctor or this police officer something that you've told me, if in order to keep you safe, because that's one of our primary obligations is to make sure our clients don't die. Okay, so confidentiality is hugely important, but there are some limits to confidentiality. There's some instances where we're allowed to break confidentiality, and there are instances where we're required to break confidentiality. So in terms of the limits of confidentiality, the big one is when there's danger of harm, and it could be harm to self. And again, I'm not going to go into too much detail about this now, because we are going to spend a lot of time talking about suicide later. But in terms of some of the legal aspects, confidentiality stuff, the decision of whether or not to break confidentiality, or more accurately, when to break confidentiality, is really going to depend on the level of risk. So if someone tells you that they thought about suicide for the first time last night, but they have no other risk factors present, so they have maybe no family history of suicide, they're really low on impulsiveness, they've got a good support system, they're just kind of going through a difficult time right now, they're not using or abusing alcohol or drugs, risk is pretty low. You're probably not released from your obligation to maintain confidentiality there. Go, I'm a little worried about suicide, I'm going to tell somebody. You could do that, but your client would be well within their rights to bring a complaint against you to the ethics board, saying that you unnecessarily broke confidentiality. So exactly where that threshold is in terms of how high the risk gets before you break confidentiality, that's something that is really hard to kind of give you a definitive answer on. It's something that you have to come to really through experience in your kind of supervisor experiences, until you know, okay, if these things are happening, I'm going to break confidentiality, and if these things I'm not. And again, it's a pretty individualized thing, because you may have some pretty similar circumstances with two different clients. With one client, you need to break confidentiality, with the other one, it may be a little more ambiguous. So it's all about the level of risk, and it's not a low threshold, because suicidal ideation is pretty common with depressed clients, and if we don't let them talk about it without calling the police or putting them in the hospital every time, then they're not going to talk about it. And if they don't talk about it, they're not going to get better. So you have to give them some room to talk about those things, even though it's uncomfortable for you as a therapist to hear that. But if the risk is high, so high risk, there's an imminent threat, so not just someday they're going to kill themselves, I definitely know, but they're going to hurt themselves soon, then you're allowed and obliged to break confidentiality. And if you're being supervised, supervise no, but you're also going to need to involve probably some law enforcement if you're not in a hospital setting, because the thing to do is to get the person to a hospital, because that's kind of a controlled environment where we can kind of keep people safe, at least for a short time. So you probably want to call the police or the sheriff. And who you call really depends on what city and county you're in, because different law enforcement agencies will differ in their amount of training dealing with psychological issues. And really, preferably, you do this with the client. The client knows you're doing it, and even having the client do it. Okay, I'm really worried about you. You said that this is the end. You can't take it anymore, and you've got a gun at home, and you just want to tell me goodbye. And I can't let that happen. I've got to accept to make sure you're safe, because that's really important to me. So we need to get you a ride to the hospital. So we need to call the police. Do you want to call, or do you want me to call? And you don't let them go, okay, I'll call on my way out, see you, bye. No, it's like, here's my office phone right here, let's call. And you can dial them. If they're together enough to talk, great. If not, then you kind of take that over for them. And then again, my advice, and this is just advice, is for you to ride with them to the hospital, and that's where they're going to be evaluated by somebody probably from MHMR to determine whether or not they'll be admitted or not, and they can initiate kind of a civil commitment or temporary hold, and psychologists and counselors can't initiate that. So I can't order somebody to be held in the hospital. I can encourage them to go to the hospital, I can ride with them, but only law enforcement can kind of put a hold, or medical doctors. They have that power. And it differs from state to state how long the hold lasts. In Texas, I think it's 24 hours. California, maybe 72. And then for any time over that, different legal proceedings need to occur. Sometimes doctors need to sign something. Sometimes it involves getting a judge to sign an order. But you can get into those details if you want to at a later date. But just know that there are processes in place to keep people safe. But the first step is generally getting them to a hospital. Now, it's important to note here that we are violating one of our key principles of autonomy, right? In deference to beneficence here. We're taking away their right to kill themselves because we think that's bad for them. And kind of one other thing about this, and again, we'll talk more about suicide later, but in terms of ethics, you're also ethically obligated to follow up with that client. You don't just dump them on the doctors. Okay, you're at the hospital, good, see you later, bye. Whew, go back to your office. That was stressful. Which you will do that, and you will talk to colleagues and supervisors about it, because it will be stressful. But you need to follow up with that client because the risk for suicide upon release from the hospital is really high. Right? So you want to make sure that there's a plan in place for their discharge, and as their therapist, you should probably be part of that plan. Even if you kind of met them in kind of a crisis situation and have no history with them other than they walked in your office once, yeah, now they are your problem, and you are obligated to help them. And if you're not capable of helping them, find somebody who is. Okay, in terms of harm to others, or maybe even you, this gets into kind of the duty to warn obligation. And I'm going to get into that in more detail in just a little bit after we look at some other instances where you may break confidentiality. So just kind of hang on to that thought for a minute. We will come back to it. Another instance when you're required to break confidentiality is whenever you have suspicion of abuse of a child, older adult, or a person with disabilities, so any kind of vulnerable population. And the threshold for breaking confidentiality here is much, much lower than for suicide. Right? For suicide, if you kind of think, oh, they might kill themselves, you don't break confidentiality. It's when you really think, oh, they're going to kill themselves, now you break confidentiality. With abuse, if you suspect it, you are required legally and ethically to report that abuse. And again, my advice to have any hope of maintaining a therapeutic relationship and helping this person move forward and not just kind of get swept away in the system is have them call themselves while they're in your office. Have them report themselves and talk about why you're doing it, the importance of keeping everybody safe, and that that they're committed to not hurting people. And depending on why you think they're doing it, you may talk about that. But have them call if possible. But if not, then you report yourself. And if you believe the victims of the abuse are in imminent danger, so you've kind of said, okay, I'm required to notify the authorities about this. If they kind of storm out, I'm going to kill them. Then that duty to warn stuff, we'll talk about in a minute, kicks in. Another thing is litigation. If a client is going to sue you for any reason, then you're able to break confidentiality. You're not required to break confidentiality, but you're allowed to break confidentiality to defend yourself in court. So of course, for all these things, you're going to want to notify the client as part of your informed consent that these are the exceptions to confidentiality, and you can break confidentiality in some instances, and in some you will be required to break confidentiality. The last one where you're required is when a judge tells you to break confidentiality. And this is when a judge issues a court order for your records or for some testimony. And again, you can say no, but you're going to go to jail. Right? You're going to be held in contempt of court, and they're probably going to get him eventually. But you could, if you think ethically I'm not going to share those things, they may very well punish you. An important distinction to make here is you give your records when there's a court order from the judge. You don't give your records when a lawyer sends you a subpoena, right? A subpoena is a fancy way of a lawyer saying, hey, please give me this. But they make it sound like they're not saying please and that you must do it. You must respond to a subpoena. If you don't respond to a subpoena, you can get in some pretty big trouble. So you respond, you say, I received your subpoena, but you don't just give them the records automatically. You check with your client and say, okay, I got the subpoena from this thing. This comes from your lawyer. What's going on? And if they say, oh yeah, it's my lawyer, you say, okay, write down a piece of paper that you want me to release the records. So get consent for release, and then you give it. Otherwise, you're going to maintain confidentiality and say, I received the subpoena. I'm not at this time able to acknowledge that this person is my client because all clients I see, which this person may not be, have the privilege of confidentiality, and I am ethically obliged to honor their right to have their information not shared. Okay. So limit confidentiality, make sure they know them before you get into work if possible, which again, in crisis work, sometimes you don't have time to go over all these details, but you want to hit at least the high points, tell them that there may be instances where I've got to let somebody else know what's going on to keep you safe, or if anybody else is in danger. Okay, so I promised to talk about duty to warn. So the big ruling everybody talks about for duty to warn is the Tarasov case, a major court case that's really influenced laws and policies on this issue. And it goes back to university in California where a student told the counselor about kind of this obsession with this girl, and kind of angry and violent, and the counselor said, oh, this is scary. So the counselor broke confidentiality and told campus police, said, I think this guy is a danger to this other student. Campus police investigated, talked to the student who was the client, and from their investigation they determined that he wasn't a threat, but he was all talk. Fast forward a few weeks, he kills the girl, and then the parents sue the police, the university, and the therapist. You think, well, the therapist broke confidentiality. Yeah, but the therapist didn't tell the girl, and that's kind of the parents' case was nobody warned her. She could have taken steps to protect herself if she had known that somebody was out to hurt her. So the ruling that came down from the California Supreme Court, again, not the federal court, but the state Supreme Court, the state decision, was that therapists do have an obligation to use reasonable care to protect the intended victim against danger. Okay? Reasonable care to protect the intended victim. How that's interpreted in California is that you do have a duty to warn the victim. And there's a couple of states where that's the case too. But in some states, including Texas, that is not the case. It doesn't work that way. The Attorney General issued a statement clarifying our state laws and kind of reinforcing the importance of confidentiality and saying that you do have a duty, but it's not a duty to warn the client, it's a duty to protect. So your duty is to notify the authorities. If you have a client who's clearly going to hurt a particular person, you need to tell the appropriate authorities. If you notify the victim in Texas, it's not yet clear what would happen to you. Right? It's possible that your client could file an ethics complaint and a complaint against your license. We won't know what will happen until somebody does that and it kind of goes before the board and goes through the court system. It probably will happen in the next couple of years, so we'll find out, but we don't know yet. But one thing to think about is, well, why is Texas different than California, other than obstinate? Well, what would happen if you had a client tell you, I'm going to go kill my girlfriend or my boyfriend? And you said, oh, crap, I've got to warn them. And maybe you're at a student counseling center, so you have access to the records, and you call that person, hey, get out of town, so-and-so's coming, and they're going to hurt you. Well, Texans are fairly well armed, right? And culturally take a lot of pride in defending themselves and their property. So it's possible that your client goes to see their boyfriend or girlfriend, knocks on the door opens, the victim now becomes a killer, and shoots the person before they say anything because they fear for their lives. And it could be that your client was all talk and they really weren't going to hurt them. And now they're dead, and you may be liable, you may be responsible for that death. So that's why in Texas, we notify the authorities, because the authorities go to the person's house and provide them protection for fear of kind of the vigilante type justice that may be carried out otherwise. Okay. HIV presents a kind of unique aspect of the duty to warn from a special case. And the laws vary state by state in terms of if you have duty to warn, in terms of if you're seeing a client and they tell you, you know that they're HIV positive and they're having unprotected sex with an identifiable person, does duty to warn kick in? Well, sort of. In Texas, you're permitted to break confidentiality, but again, you're not permitted to tell the partner, probably for the same reasons as we saw with the kind of Terrasol ruling. Who you tell is a state agency, and the state agency informs the partner and provides them information and counseling about how to get tested and how to protect themselves. But again, you're not mandated. It's not a mandated reporting thing like suspicion of child use. You're allowed to report. So that's the legal side. The ethical side is even, I think, less clear. And this is another thing that I want us to talk about in class is, what do you think if you were the therapist, would do or should do? So, what's the right thing to do, and why? Why is it the right thing to do? The last thing in terms of duty to warn, essentially, if you are the target, obviously you can warn yourself. To be the target of client violence is rare, but it does happen, and you're allowed legally, ethically, to do what's necessary to protect yourself, and you aren't required to treat someone who poses a threat to you. That being said, you can't abandon a client who's just a little scary. So, like much of what we talked about, you've got to do a risk assessment and make some judgment. So if you have a client who's kind of gruff and maybe bigger than you, and it's intimidating, you can't say, oh, well, I'm scared they may hurt me, I'm not going to see them. Especially if you've established a relationship with them, that would be client abandonment, and that's an ethical violation. But if they tell you they actually are going to hurt you, and you have reason to believe, kind of a reasonable person would say, yeah, they are going to hurt you, then, yeah, you can refer them out. But if it's just you being nervous, then no, you're not off the hook in terms of your ethical obligation to do the best you can for that client. Okay. The last thing, and probably not as much an issue with crisis intervention work as with long-term therapy, but it's still, unfortunately, a problem in our field, and so we still have to talk about it. Having sex with clients, don't do it. Clearly, don't have sex with your current clients. It's a major ethical violation and against the law in Texas, violates the state law. And if you know of somebody else that's done this, you should report them to the appropriate state agency. Because it's potentially incredibly harmful to clients to do this, and it certainly is an abuse of power, because there is a power differential in the therapy setting. In terms of former clients, this is where it gets a little grayer, at least for some people. And different ethics codes word this a little different. Most of them say, at some point, it's okay. But most of them put kind of this waiting period, 5 years, 3 years, whatever it is. And after that, it might be okay. My advice is, no, still don't do it. One way that this is relevant for crisis intervention is you may think, well, what if I meet someone as part of a crisis in the field? Again, there's that turnover bus, and I go and I talk with someone for 20 minutes, kind of get them to where they're with it enough to go get in an ambulance and go to the hospital. have I now established a professional relationship, and can I never have sex with that person? And it might be a bigger deal if you're in kind of a small town and there's limited options for romantic partners. So maybe that's the person who's going to be your husband or your wife or your partner and your dream person, and you have the unfortunate luck of having this 20-minute semi-therapy interaction with them. So can you never be with that person romantically? Depends. And again, the shorter the interaction, probably not as big a deal. But what it depends on really is foreseeable harm. So if you were to engage in a romantic relationship with this person, how likely is it that it would cause harm to them? And again, not harm to yourself, because the ethics code, not too worried about counselors. There's some stuff in there for us, but mostly it's protecting the client. But is there foreseeable harm? So, what are the risk factors? When might it be more likely that harm is going to happen? Well, obviously, the longer the therapy interaction and the greater the depth. So if you do, if you do a 20-minute guest lecture on parenting, for your church, and somebody's in the audience and they hear your guest lecture, and you have some group interaction, so it's sort of like group therapy, but not really. That's probably okay to date that person. If you saw a client for a year in individual therapy, now you're much more likely to cause harm because it's more of an established therapeutic relationship, and the more established that therapeutic relationship is, the more likely you're going to cause harm leaving that relationship and trying to enter into this other romantic relationship. Other things, if the person has a history of sexual victimization, if they suffered sexual abuse or rape, they're especially vulnerable to being taken advantage of by someone in a more powerful situation. So don't do it then. Take into consideration the emotional stability of the other person. If it's a client who's just coming in for smoking cessation and they're pretty high functioning, you see them for a little while, maybe not a big deal. If somebody comes in and they've got all kinds of relationship issues and some maybe father or mother issues, and they kind of latch onto you and think you're the greatest thing ever, even if 10 years go down the road, it may really be damaging to enter into a romantic relationship with that person. If there's any kind of intertwining of romance and your therapy, so if you talk about dating while you're seeing them, that's a big no-no, and you're going to cause harm, and that is unethical. And you can't say, "Oh, I really like you. Let's terminate therapy so we can date in 5 years." That's also a violation of the ethical code, and potentially really harmful. Okay, so as a rule, don't have sex with your current clients. Don't have sex with your former clients. In some rare exceptions, it may be okay to have a former client as a romantic partner, but you better be really sure that you're not going to cause harm. And the burden is on you as a therapist. And it's not on them. It's like, oh, well, two of us are in it together. We'll make the decision. No, it's your burden. You have the professional ethical obligations. It's your job to make sure that there's no chance that this could go south and you could cause harm. Because again, before you're kind of a person who's out there to debate, you are a therapist. Okay, so just kind of summing everything up, what I want you to kind of keep in mind, the things I want you to talk about, make sure you wrote those down. But again, as your general approach, think about that vigilant ethics. So not trying to stay out of trouble, but trying to do the right things because you understand why they're the right things. You understand what good comes of ethical practice. But you also need to be familiar with the ethics codes that apply to you depending on your kind of professional orientation, identification. And also, it's important to learn the laws of whatever state you're going to practice in, and find some way of staying up on that, if it's through continuing education or whatever the avenues you may pursue. All right. I'll talk to you later.